Good morning or afternoon to you all. My name is Hannah Behrens and I am the Associate Director at MPI Europe. I would like to warmly welcome you to the webinar called Legal Channels for Refugee Protection in Europe, a pivotal moment for strategic thinking. We are very pleased to have the following speakers with us today. Mr. Brian Salland, Research Assistant with the Migration Policy Institute's International Program. Ms. Susan Fratzke, Policy Analyst and Program Coordinator with the Migration Policy Institute's International Program. Mr. Brian Merriman, Principal Officer for Asylum Policy at INIS within the Department of Justice and Equality in Ireland. And finally, Mr. Janne Grote, Policy Analyst at the National Contact Point of the European Migration Network, based at the German Federal Office for Migration and Refugees. First, I would like to draw your attention to a few housekeeping notes. Firstly, we would like to remind everyone that the audio from the webinar will be on our website later today. You can find it at migrationpolicy.org/events. If you should experience any technical problems, please email at events@migrationpolicy.org. Or if you have problems hearing via the web, please dial in using the call information sent earlier via email. After the presentations, we will have a written and not a voice Q&A, and so please type any questions you may have into the Q&A or chat box on the right side of your screen, or email using the following email address, events@migrationpolicy.org. You can also tweet your questions to @migrationpolicy or #MPIDiscuss. There are two papers that feed into today's discussion. These are both available on MPI Europe's website, www.mpieurope.org. The first one is called Tracing the Channels Refugees Use to Seek Protection in Europe, and this one was developed in the framework of MPI's work for EPIM, or the European Program for Integration and Migration. And the second paper is called Engaging Communities in Refugee Protection, the Potential of Private Sponsorship in Europe. And this flows from the work that MPI has done in the spring of this year for the Open Society Foundation. Let's now turn to the substance of today's webinar. As the numbers of arrivals of third country nationals rose in 2014 and 2015 in Europe, the call for a greater use of safe and legal pathways to international protection grew stronger. More places were asked for, but also a wider range of legal pathways was considered. Many dug up menus of resettlement, private sponsorship, humanitarian admission, family reunification, but also migration for labor or educational purposes. In September 2017, the European Commission proposed a new resettlement scheme with at least 50,000 additional resettlement places for those in need of international protection. In addition, it encouraged member states to establish private sponsorship schemes. And it also tasked the EASO, the European Asylum Support Office, to coordinate a pilot project on private sponsorship schemes with interested member states. In September 2016, the New York Declaration for Refugees and Migrants also expressed the intention to expand the number and range of legal pathways available to refugees. While we may applaud the increased commitment, this should not preclude the question whether these legal and safe pathways make up a smorgasbord, as an official in resettlement recently put it. Does the common denominator of these being legal and safe pathways render these pathways interchangeable, or a pool from which policymakers, politicians, and program designers can pick and mix? Can they simply select from this menu to fill the national quota and to do so within the budget they set aside to receive and integrate these refugees? As the webinar will point out, there are a number of strategic and operational issues that need to be taken into account when developing a policy concerning legal pathways. And when it comes to the numbers, what information would policymakers and program designers usefully be able to consult in terms of who arrives, with what profile, and through which type of channel or route? This is crucial if the strategy is to fulfill the political ambition of turning an irregular flow into a more regular and managed one. I will now turn over to Brian Salland and to Susan Fratzke. Brian is a research assistant with the Migration Policy Institute International Program, where he focuses on skilled labor mobility, qualifications, recognition, and public attitudes towards migration. Prior to joining MPI, Mr. Salland worked at the public diplomacy section of the US Embassy in Ankara in Turkey, and later at the Merriman International Center in Washington, D.C. Ms. Susan Fratzke is a policy analyst and program coordinator with MPI's international program. Her research areas include forced migration, asylum, and resettlement policy, with a particular focus on Europe. Before joining MPI, Ms. Fratzke worked for the U.S. Department of State's Bureau of Population, Refugees, and Migration, and she also worked at an adult literacy program serving immigrants and refugee students in Minnesota. I would like to now invite Mr. Brian Salland to provide his presentation. Thank you.
Well, good morning, good afternoon, everyone. I'm going to present a little bit of some of our findings from our paper about tracing the channels refugees use to seek protection in Europe. Our paper looked at what channels of entry are used by protection seekers to arrive in Europe and found that legal channels for entry account for only a fraction of those granted via the spontaneous asylum system. We know that a majority arrive through non-humanitarian channels and are granted protection via the spontaneous asylum system. The data we collected suggests, as many in the migration field assumed, that a plurality arrive without authorization, which poses several problems for governments. Firstly, populations are losing confidence in the government's ability to manage migration, and spontaneous flows present a huge burden on government resources, both in adjudicating claims and offering basic provisions to those waiting on status determination. As a result, policymakers are looking into ways to expand legal pathways to entry, as these may change the calculus of protection seekers who might otherwise undertake unauthorized journeys, allow those who do arrive and receive protection to quickly gain status and begin contributing to the host countries, and most importantly, provide more safe and orderly pathways to entry. So resettlement is the traditional tool used to provide a legal channel of entry, and it has increased roughly 2.5 times since 2014, from approximately 7,500, this is across the EU, to 18,000 places, but it has failed to keep pace with the protection demand. And as we can see from this chart on the left, spontaneous asylum protection granted through the spontaneous asylum system versus those welcomed through resettlement in 2016. Now, our paper looked at 4 legal pathways of entry, and these were resettlement, humanitarian admissions programs, humanitarian visas, and family reunification. And I'm briefly just going to set out those 4 channels. Through resettlement, accepted refugees in a country of first asylum are allowed to settle in a safe country, typically with permanent residence, and in many cases an eventual pathway to citizenship. Humanitarian admissions programs are usually one-off, short-term programs with a target population brought to a safe country for protection, and they vary in the visas used to facilitate this entry and the status conferred to beneficiaries after their arrival. Humanitarian visas are a tool for movement, but they're also considered a separate legal pathway to entry, which require application through the asylum system after arrival in a host country. And family reunification is a separate part of the migration landscape in which immediate family members of an individual given a status in a host country may join them and receive the same status. what we found in our paper is that there's a lack of clarity about these channels, and there's a lack of disaggregation of data so that we can understand the impact that each channel is having on providing new pathways, new safe ways to entry, and providing those pathways to different populations. So because of the difficulty in finding disaggregated data, there's problems of measurement, and these programs are difficult to monitor and evaluate and understand their strategic impact in terms of protection outcomes and changing the calculus of those in first asylum countries. So some examples of this overlapping data are that member states may sometimes classify entries via humanitarian admissions programs as part of formal resettlement, while others do not. And as a result, we don't know how this channel is working to complement resettlement across the EU. Humanitarian admissions programs may also operate in conjunction with the asylum system or apart from it. And this sometimes results in double counting the data, where we see someone coming in through a humanitarian admissions program and then being counted again as they apply through the asylum system. In other cases, we lose track of those who've entered via this channel once they apply through the asylum system. Likewise, humanitarian visas are often conceived of as a separate legal channel. But once people arrive in host countries, they apply through the asylum system, which can again lead to double counting or make it difficult to evaluate their effects, as those are lost once they apply through the asylum system. In other cases, humanitarian visas are used to facilitate the entry of beneficiaries of a humanitarian admissions program, meaning that it's difficult to separate the impact of each of those programs. Given that these mechanisms often overlap in their target populations, goals, and resources, they may be difficult to expand efficiently with a full understanding of the resource needs of each channels and possible capacity constraints of expanding them. And likewise, it's difficult to coordinate these channels across the EU when their definitions may differ from member state to member state. So one example, when a member state might be investing in several programs and expanding one would reach the same population. And an example of such a program might be the Humanitarian Corridors program in Italy and France, when people are brought on a humanitarian admissions program, which is also considered to be a private sponsorship program sponsored by the community of Sant'Egidio, and using a humanitarian visa. One major legal channel that we found is under-considered in this whole question of legal pathways is family reunification with a protection beneficiary. Based on our research, we think this channel is being widely used. In countries for which we could find data, each showed that the number of people offered protection via this channel has been regularly half the number receiving a positive asylum decision. This channel may also be a low-hanging fruit, since family members without a legal pathway might be likely to try unauthorized routes, as they have a high likelihood of receiving protection. But we lack the data to understand the scale of this channel across the EU. And one of the reasons for that is that family reunification data is often not disaggregated by the status of the family member in the host country. So in closing, one of the major takeaways of our report is that due to a lack of conceptual clarity and consistent data about the legal pathways to entry, we don't have a complete picture about how these channels are used, and thus they are difficult to monitor, evaluate, coordinate, and expand. So now I'll turn it over to Susan to discuss some of the big picture questions about these legal channels, as well as private sponsorship.
Thanks so much, Brian. So as Brian said, one of our our primary goal with this report was, of course, initially to identify what data is available about how protection beneficiaries are entering the EU, both through spontaneous asylum systems as well as through legal channels, and then to determine what that data tells us about how those channels are being used. And as Brian said, what we discovered is that there's a lack of clarity in how data is being collected and reported, and as a result, we don't always have a clear picture of how people are entering and the relative impact of different channels. Beyond a research perspective, of course, which is what interests us, there are a number of policy and, I think, strategic and operational questions that the report raises. As Brian already mentioned, I think the strategic impact of programs is one of the key questions that we have to ask ourselves, given the lack of clear definitions and often overlapping ways of measuring programs. If one of the goals of EU action and, in fact, many member states' national priorities at the moment is to expand the number of legal channels that are available and, in fact, have a strategic impact on protection conditions on the ground and perhaps even onward migration from first asylum countries, how can we achieve strategic impact if we're not entirely certain, in fact, how many protection spots are available and from where and for whom? On the operational side, I think there are a number of other questions that the findings raise. First of all, given the proliferation of different ad hoc programs, there are, in fact, many different programs often running in the same country that provide different legal status and rights to similar groups of individuals or groups with similar needs. Does this proliferation of different statuses, in fact, have an impact on integration or eventually social cohesion down the road? What are the administrative consequences of having to renew different types of permits or ensure that service providers are aware of the different types of rights that different groups are receiving? Also on the administrative side, as Brian mentioned, many humanitarian programs use asylum systems. What are the administrative implications of running programs through systems that are already facing large numbers of spontaneous asylum applications? And of course, on the back end of the process, what provisions need to be made for the reception of arrivals? Of course, there's also the question of cost of repeatedly scaling up and then tearing down administrative infrastructure of ad hoc programs. If a new program is created every time a new need emerges, and then that program is stepped down once that need disappears, what are the long-term costs of then having to rethink and reevaluate how you're doing that program 2 years down the road when there's again a need to offer 10,000 protection places? There are a few implications then, I think, once we face these strategic considerations. And MPI's work both on this paper and our other work on resettlement, I think, points us first to a need to think beyond ad hoc programs to how we build a more permanent infrastructure for resettlement and humanitarian admission, particularly in the context where the EU is thinking through the possibility of an EU resettlement framework, or how to build protection through resettlement into the asylum system in a more long-term way. How can we ensure that member states have the capacity to offer legal channels to protection on an ongoing basis, rather than rebuilding the system every time a new need and or new demand emerges? At the same time, I think the number of different channels that are on offer also points to the need to be flexible, both in terms of being able to scale up to meet new demand and also, in fact, to meet niche or new needs when they emerge. One example of this can be found in the U.S. resettlement context, where until this year, the U.S. resettlement program actually maintained an unallocated reserve of resettlement places that could then be distributed based on need if a new emergency came up during the course of the year. So there's a need to think through tools such as that could be built into a more long-term resettlement program. I think one of the other implications of the report is also the need for better coordination and perhaps common definitions of some of these programs across EU member states. Initiatives like EU Frank, which seek to share knowledge and practical capacity even among member states, are one way to do this, to try to achieve a more common understanding of target groups and the conditions under which target protection groups are being brought in. Finally, one of the other findings that's emerged from this project and some of our other work in the area of resettlement is the need to consider the goals of initiative from really the beginning of a program design. So what are you trying to achieve, and what type of design is needed to achieve that ultimate goal? Do you need a new program to achieve that goal, or can an existing program be modified to fill that same need? Along these lines, I wanted to spend just the last few minutes I have here talking about one channel in particular that's received a lot of attention, and as Hannah mentioned, that we've been investing quite a bit of time in here at MPI, and that's private and community sponsorship of refugees. As Hannah mentioned, we recently released a paper looking at how private sponsorship might work in the EU and where it might add value. And as part of this initiative, we mapped existing EU member state initiatives that had elements of private or community-based sponsorship. And I think these types of initiatives illustrate quite nicely many of the different trade-offs and constraints that Brian and I have been discussing. First, though, it's worth briefly defining what exactly we mean by private sponsorship of refugees. And in fact, I think the analogy of a Rorschach inkblot test is quite apt here. In fact, if you ask someone to define private sponsorship, I think in many ways the answer may tell you more about them and their goals than necessarily about what exactly the program itself is. There's a lot of different ways to think about private sponsorship and to actually do private sponsorship in practice. Traditionally, private sponsorship is conceptualized along the lines of the Canadian model of private sponsorship, which is the largest and longest running private sponsorship program. The Canadian program operates in addition to government resettlement channels, where individuals and organizations actually identify people outside of their countries for resettlement and then take on full responsibility for the reception and integration of those people once they arrive. But as I said, sponsorship, and I think our work points to this, can come in many different shapes and sizes and types of programs and serve many different types of goals. At its core, sponsorship is about involving community or private groups and stakeholders, though, in refugee reception and resettlement process as key stakeholders to those programs. Sponsorship programs can serve many different goals and, in fact, add value to resettlement or asylum systems in many different ways. First, along the lines of the Canadian model, they can serve to create an additional legal pathway to protection. As in Canada, if sponsorship programs operate in a manner that the individuals who are being brought in actually are additive to the individuals that the government is bringing in, they can actually serve to increase the number of resettlement places on offer. In addition to the Canadian program, the humanitarian corridors programs in Italy and France are examples of this, where the individuals who are being brought in as part of these programs are actually on top of those countries' existing resettlement commitments. Sponsorship programs, though, can also serve to create additional channels in terms of the scope of the program and who is actually being brought in. So where sponsors are allowed to identify individuals for resettlement, they might actually allow resettlement to reach a different target group than a traditional resettlement program, which targets the most vulnerable. Many sponsorship programs actually aim to facilitate reunification of extended family members. So the German Land-level humanitarian admission program that ran until recently is one example of this, where the program allowed family to actually nominate extended family members abroad and bring them in and then take on the cost of supporting them. So again, that allows resettlement programs to reach additional people, not just additional numbers. Finally, sponsorship programs can serve to actually improve integration and community cohesion, in part by giving communities and individuals a voice and a stake in protection programs, so allowing them to actually become participants in providing protection, but also by creating durable and close connections between sponsors and refugees that provide them with more individualized services. The main takeaway, though, I think, is that design of programs will actually need to be quite tailored depending on what aim and which of those goals you're trying to achieve. There are many different ways that sponsorship programs can operate. As we found in our mapping process, they can serve, as I said, as a separate additional channel that operates in parallel to the resettlement program. They can also operate as a complementary channel within an existing resettlement program. So if the goal is simply to bring communities into the resettlement process, one option is something along the lines of the UK model, which actually operates resettlement within the country's operates sponsorship within the country's existing resettlement commitment. And finally, they can operate as a complement to the asylum and reception system. So sponsors could be involved in the receiving and integration of refugees who actually come in through the asylum system rather than as an additive to the resettlement system. As I said, though, the main takeaway, I think, is to really consider what the goals are of the program and what AIM is trying to achieve, and then how it relates to the other programs that are already being implemented. How does sponsorship fit with resettlement? How does it fit with humanitarian admissions or with a spontaneous asylum system? And think of it as one tool in the broader toolkit to facilitate legal entry. Finally, there's also a need, I think, to think about how to build up sponsorship programs in a sustainable way, not simply as a one-off to meet a particular need, but what sort of capacity and long-term frameworks do you need to actually develop a program that will be lasting, that you don't have to rebuild again 2 years down the road. With that, I'll turn it back to Hannah and to our other speakers. Thank you very much.
Thank you, Susan and Brian, for giving us a flavor of the work you've been involved in. I would now like to introduce Mr. Brian Merriman. He's a Principal Officer for Asylum Policy at the Irish Naturalisation and Immigration Service within the Irish Department of Justice and Equality. And based there, he has responsibility for policy inputs on asylum matters such as the International Protection Bill. He also contributes to developments at the European Union as a representative of his organization, and he liaises with UNHCR and NGOs and supports Irish asylum agencies in fulfilling their mandate. He will now shed light on the degree to which Ireland has been using these different legal channels, such as resettlement and the humanitarian admissions program, and also reflect on the role that these different channels play in Ireland's protection policy. Brian, the floor is all yours.
Thank you very much. Good morning and good afternoon to everybody, and thank you to Brian and Susan for their excellent paper. I suppose Ireland, being on the periphery of Europe, has not been affected by a mass arrival of people on our shores. We're quite difficult to get to. And also the Irish context is somewhat different than other EU member states, and to be fair, I think it's been quite helpful. We don't have any anti-immigration parties in our Parliament, or indeed members of Parliament don't espouse such policies. Ireland is very conscious of emigration. I suppose starting back in the 1800s when we had a serious potato famine here, we lost 1 million people died, and then some more millions emigrated over the coming decades, mainly to the USA, Canada, Australia, to the United Kingdom, where we have a common travel area with freedom of movement regardless of our membership of the EU, and of course South America and Australia. So emigration, movement of people, loss of family, etc., is very much in the Irish psyche. We also have a situation here, I think, where we're a small country. We have small NGOs who are not necessarily hugely resourced. And for example, unlike most of the countries in Europe, they don't run reception and accommodation centres for us, which is a challenge. So essentially the response has primarily been a burden on the state. I know Canada, for example, has been able to work with private and NGOs to kind of share the burden and indeed to come up with pathways where other people take responsibility for them. We are not in that position. People may also know that we did have an economic crisis, particularly around the construction industry here, so we still suffer from a great shortage of housing and accommodation, and that is actually a bigger influence on what we can do and the numbers we can take in rather than a political will. I believe the political will is very strong in Ireland to respond to the humanitarian crisis. There is also a difficulty from the policy point of view, and that is about the use of language. Obviously, there are international norms where countries and states offer protection to people who no longer get those protections in their own country. But I think it's important to understand that the asylum system is actually now dealing not just with people in need of international protection, but also all the other people that don't have a legal pathway into other countries for economic or other reasons. And that has put a great pressure on the entire asylum system. It slows it up. It means that people in need of protection are in a queue with those who are not entitled to that protection. But it also means, of course, that we can't, and I think a comment was made earlier, just pick the people. We like it or not, there are 1 million plus people on the mainland of Europe, and we need to respond to their needs, whatever they be, either economic or indeed protection. But it is important to note that language, that there is a big difference in framing a legal pathway when you're looking at the needs of asylum seekers, people who are granted protection, and other types of migrants. And unfortunately, they're all kind of, I suppose, lumped in together now. So the discourse in Europe has obviously been prompted by the very serious situation that arose in Syria, etc. But there are many, many, many other nationalities, and also people fleeing the economic problems, etc., from the continent of Africa, for example, or sub-Saharan Africa, that are also landing on the shores. And I think we need to be very clear that their circumstances are not equivalent to the ones in the conflict zones and vice versa, and that responses that are devised and legal pathways should honestly recognise those differences and see how we can respond to those. For example, when we cooperated with the Greek authorities to take in people, we knew that everybody that we took in had a very high likelihood of being granted full status when they arrived in Ireland, and that has turned out to be the case. And that has made it very possible to plan and to provide services for people. Going back to 2014, when this first became apparent in Europe, we did set up a humanitarian admissions program, which is called SHAP, the Syrian Humanitarian Admissions Program. And we originally designated 500 places for that, but it was very dependency-based. So in other words, you really had to know somebody or have somebody in Ireland, usually a relative here, who had the financial means to take you in, who could accommodate you, and indeed there was an implicit condition in it that you would not apply for asylum. How did that turn out? Well, about 114 people took up places of the 500. Many people are from families who, by virtue of conflict, etc., don't know each other very well. So the notion of an adult nephew and his wife, or a niece and her husband or partner coming over and living with an uncle that they may not have seen for many years proved difficult for the people who availed of that, and well over 50% of the people who arrived actually did then enter the asylum process, regardless of whether the program allowed for that or not. So we decided to upgrade our process. I think when the relocation and resettlement proposals came from Europe, Ireland was in a position where it could choose to opt into these, and happily and unanimously from our Parliament, Ireland did agree to opt into these programs. Initially, we said we would take 260 people a year for 2 years, but happily we reached that target of 520 within the first year, and then we doubled it. And we have also, and will have reached that target very shortly. And that really was about a tenfold increase in our normal resettlement programs into Ireland. We also upgraded, I think, the status of protection we were giving people. Resettlement people were identified mainly in Lebanon and came over to Ireland with a guarantee of status, and then we promised relocation people a fast-tracking system which has worked, and they get status within 8 to 12 weeks. They are not, of course, dependent on other people, And on the resettlement programs, we have a resettlement officer who works with them. We have worked with local authorities throughout the country. We've identified areas where there may be some employment, where of course there's housing, where there's access to medical care, where there's schools. And because Ireland has rural communities, also a transport system is also a key part of resettlement. As I said, we fulfilled that 2-year quota within one, and we've recently announced another pledge on the EU programmes, which is the biggest pledge we have ever done, of about 600 for 2018. There have been benefits. First of all, there's been a great welcome in rural communities in particular. In Ireland, been some very positive integration work. Because rural communities are small, some of them were in fact losing, say, teachers in schools because numbers were falling. The arrival of children under these schemes has helped maintain numbers of teachers and services in schools, etc. So that's been seen as a plus in some smaller communities. And that's something that I think that we've chosen to capitalise on in promoting integration. We've recently also brought our international protection legislation more in line with the EU norm. We had a sequential procedure which was quite cumbersome and led to delay, and we now have a single applications procedure to speed up on that process. And about 20% of all the people in our centres actually now have a status, and the accommodation crisis is making it very difficult for us to be able to integrate these people into society, find them apartments or houses to live in, which would of course free up beds in the accommodation centres, which would allow us to take in more people. So it's been quite a challenge to manage that. We also then responded to the need of unaccompanied minors who were living in the previously emerged camps in Calais. And this is interesting because the NGO sector brought this matter to our attention. They mobilised a lot of support for us, and they said that they had between 200 and 300 files of young people who would be available immediately to the Irish authorities if we bring them in. Our Parliament said, bring them in. I would have to say from then on, the kind of cooperation broke down. Those files didn't exist, but we went to France ourselves. We identified about 50 unaccompanied minors. We've 26 of them safely here, being well looked after. We've actually begun family reunification for them. The first family arrived and stayed. That was great. We found 3 of them had connections to Ireland already, so we united them. Another family did arrive, though, and because there wasn't an immediate house available to them, they left their child behind them. They left 2 other siblings with them, and they returned to the country that they were from. So we had a problem there to see and to try and boost up the services that are available, but we know there's another 5 more families on the way, and that's a happy outcome. In relation to family reunification, the recent legislative changes did bring us back more onto the European norms. You can apply for reunification with direct members of your family. However, this has proven to be a challenge for some people because A, they haven't got their applications in now within the 12-month deadline, and we are now looking to creating a new humanitarian admissions program, and I expect an announcement from government shortly on that, which will allow for people to apply for people who are excluded, I suppose, under the tighter controls of family reunification. Now, why did we tighten up on family reunification? Well, the average application that we were getting in Ireland was for between 20 and 30 extended family members. Now, there's no point in bringing them in and putting them in a different area in the country. So we had a very finite source of housing and accommodation available to us. And when we got local authorities to, say, take in 2 or 3 families, when it became obvious that that could multiply by 4 or 5 times that amount, that put strains on the supply available to us. And indeed, our record application here was one person applied for over 70 members of their families to enjoy it. And to be honest with you, things like that break a system with finite resources. in relation to profiling people, which is something I'm a bit uncomfortable with, basically if they qualify for the higher rate of recognition, we'll take them in from Greece and Lebanon, bearing in mind that the Italian authorities have not cooperated with us over the last 2 years, have prevented us from doing security checks in Italy, and as a result of that, even though we had accommodation centres available in the early part of the programme, we were prevented from taking anybody from Italy, and we used the highest political context to break that impasse, but the Italians wouldn't budge on it. And I think overall too, looking at systems and counting at numbers, it's important to note that Ireland, which has less than 1% of the population, opted in to taking people under relocation and resettlement. And we expected 160,000 people to be made available for those two programs. In fact, after 2 years, it's about 22% of people of that number were made available to all member states. So that even though we haven't reached our 4,000 target, we've actually taken in 3% rather than 1% of that quota. And I think we need to be clear and honest to be saying that at no stage were 160,000 people made available, but though we know they were in the landmass of Europe, of course, and that our programme should recognise that, because populism, be it pro or anti immigration, is used then to kind of beat up governments, you know, in relation to targets and numbers. So I think, going back to my first point, we need to really kind of reprofile the reason why people are coming to Europe and target our programs to reflect both those in need of international protection and those who have other reasons, bearing in mind that 1 in 8 in the Irish workplace is not an Irish person, so we are an open economy on that. And I think the government here will shortly announce a new response to making sure that we do fulfil our full 4,000, even though only 22% of those people were made available to it. We've also gone in relation to private schemes and sponsorship schemes. We've actually gone beyond the asylum and protection advocates, and we're now talking to the housing agencies, and that has helped us, I think, broaden out and redefine potential sources of assistance, because to be fair to the housing charities here, they absolutely recognise the right of people who are granted protection or claim protection, that they should be included in their services too, and that's been very helpful. So that's a potted update on what's happening in Ireland. It is difficult from a policy basis. It is difficult when people, there maybe should be schemes for people who are not entitled to protection as distinct, to allow us then to more rapidly provide services to those who are, and I look forward to questions and indeed a further source of information which might allow us, I suppose, plan the Irish response over the next few years.
Thank you, Mr. Brian Merriman. Thank you for shedding light on those different kind of channels, entry channels into Ireland, and actually highlighting some of the strategic and administrative but also operational challenges that you face in this regard. I would like to now introduce Janne Grote, who is a research associate and policy analyst at the German National Contact Point of the EMN, and he's based at the Research Center of the Federal Office for Migration and Refugees in Nuremberg. He has authored several German EMN studies which relate to resettlement and family reunification, and all this while also conducting his PhD. He will now also provide us with some further information on how Germany is currently utilizing family reunification and explore what this means from a practical side in terms of capacity to engage in other protection office efforts, but he will also engage with the policy-related question of how does it fit with other protection channels. Janne, the floor is all yours.
Okay, good afternoon, and thank you, Hannah, for the kind introduction and the invitation to this very interesting and topical webinar. Okay, so I was asked to complement the discussion by giving a 5-minute insight to the family reunification channel to Germany. And Hannah, first slide, please. The topic is highly relevant for Germany, as you may see on the slide and from the table. The number of issued residence permits for family reasons in Germany has doubled from 2013 to 2016 to almost 106,000 family reunifications. Unfortunately, we do not have disaggregated data yet on the status of the person already living in Germany, so we do not know how many of these were family reunifications with refugees, and a great load will not be, but there are indicators, and in the table I highlighted family reunifications of Syrian and Iraqi nationals, which are two of the main groups of asylum seekers with the highest protection rates in Germany. So you may see a great rise of issued residence permits for family reunification purposes for these two countries of origin. Almost 40,000 residence permits were issued last year in 2016, which you can see on the right-hand side, for Syrian and Iraqi family members only. And yesterday, numbers of the Federal Foreign Office in Germany were published, stating that about 70,000 Syrians and Iraqis are currently applying for family reunification to family members in Germany. So, in accordance with the European Family Reunification Directive and our national law, third country nationals who are granted the right to asylum or who are recognized refugees do have privileged conditions for family reunification in Germany, which also applies to resettled refugees who were put on equal footing with recognized refugees on 1st of August 2015. On the contrary, these privileges do not apply to beneficiaries of subsidiary protection at the moment. Family reunification has been suspended until March 2018 for all those who were granted subsidiary protection after March 2016, so a 2-year suspension. And the idea in the first place was to delay the family reunification for beneficiaries of subsidiary protection in order to not put an additional load on the receiving municipalities who at that point in 2016 struggled with the reception of the great influx of almost 1 million asylum seekers, spontaneous asylum seekers, at the end of 2015 and early 2016. And after the recent parliamentary elections 2 weeks ago, the prolongation of this 2-year suspension beyond 2018 is part of the coalition negotiations. And but also next to the beneficiaries of subsidiary protection, other protection beneficiaries maintained their privileges, of which many made and make use of. But this rise in application numbers again led to a capacity overload at the foreign embassies and consulates, occasionally resulting in long waiting periods for an application date in the neighboring countries of Syria especially. So step by step, many practical measures were put in place to broaden the capacities at the diplomatic missions, of which I would like to give 3 examples. And Hannah, please, next slide. So first of all, an agreement was signed between the German Federal Office and IOM, the International Organization for Migration, to set up 5 so-called family assistance programs in Turkey, Lebanon, and Iraq. And the IOM staff mainly helps vulnerable migrants from Syria and Iraq to compile all necessary documents and files the applications for family reunification take, so that the staff of the diplomatic missions receive complete applications on which they may finally decide on. Additionally, a web portal was launched which enables applicants to fill in notifications and application forms online, and the premises of the general consulates to Erbil, Ankara, and Beirut have been expanded, and a second visa department was opened in Istanbul at the German General Consulate to process more visa applications. Next slide, please, Hannah. And I cannot highlight all differences and similarities of the different humanitarian admission programs and schemes also existing in Germany in regard to family reunification in these 5 minutes, but I may highlight a few. So with the exception of beneficiaries of subsidiary protection, other beneficiaries of protection, including resettled refugees, are granted privilege rights of family reunification. Secondly, within Germany's humanitarian admission programs, family reunification is only allowed in exceptional cases. This also concerns parts of the EU-Turkey agreement and those who are resettled via the humanitarian admission scheme in Germany. And in regard to the private sponsorship programs, as Susan already highlighted correctly, in Germany, in some federal länder, they are open not only to the core family, but also to second-degree relatives, such as grandparents, siblings, or grandchildren. So we can see a variety of interlinkages of family reunification with other legal channels for refugee protection in Germany, with restrictions for some status groups in order to limit the load, and channels on the other hand with privileged access. And in the annex of my presentation, I included the most recent numbers for 7 different humanitarian admission schemes and programs channels in Germany, which you may look up afterwards. I think there's no time yet at the moment, but maybe later in the discussion to get back to that. So that's all from my side for the moment. Thank you very much for your attention, and I'm looking forward to the discussion. And next slide, please.
Thank you, Jana, for introducing us to and giving us more information as to the current use of the family reunification policy in Germany and how that links with other protection efforts at the moment there. We've now come to the Q&A session of the webinar, and I would invite you to use the Q&A function on your screen or to email any questions you may have to events@migrationpolicy.org, or to tweet your questions to @migrationpolicy or #MPIDiscuss. A first question that we've received from the audience is for some further clarification in terms of the use of these different channels, such as humanitarian visas vis-a-vis resettlement. So while we so far have presented how, for example, EU member states use these different channels, or maybe even in combination, as Brian has described it, the audience is asking, so if you would look at it from the refugee who suddenly has to flee from his or her country of origin, what kind of options are there available? How quickly can they access these different kinds of tools? And I would like to reach this question out to Susan and Brian to reflect on, can we explain briefly how a humanitarian visa may be used, depending, of course, if a member state puts that available, and how they would actually access resettlement and how quickly that can be done.
Sure. So I think it's an excellent question, and one of the things that, as Brian said, our report really revealed is that there's not always a lot of clarity as to how humanitarian visas are used or how member states, in fact, intend them to be used. I think one important point that we need to be clear about is that when we're talking, in most cases, though, about humanitarian visas or humanitarian admission, resettlement, generally, these are tools that are used to provide a channel to long-term protection for people who are in first asylum countries. So for someone who's already left their country of origin where they were in imminent danger and found temporary safety in another country, these are tools that are used then to provide them with a more sustainable and durable solution or way to access protection. Many times conditions in first asylum countries are very poor. Those countries are under strain, and so this is a way to help those countries and provide solidarity and relieve some of the pressure on them. In terms of humanitarian visas themselves, I think our report showed that in some cases they may be used as a tool. So a humanitarian visa may be used to actually provide someone admissions to resettlement or to a humanitarian admissions program. So simply as the visa that actually allows them to travel from one country to another, and then they receive another status once they get there. In other cases, though, there's been debate about using humanitarian visas in fact, as another channel of entry. So opening the possibility to apply for a humanitarian visa in a transit country in Africa or in another transit country in the Middle East. So actually allowing people a legal pathway to the asylum system. But it really varies depending on the country that you look at, how exactly something like a humanitarian visa is used and with what goals in mind.
That's a very good question, I agree, and there is a dilemma, I think, between two systems. You can't apply for protection outside a country, you know, and the first country you land in the EU has an obligation to that applicant. And I think the immigration side of the House, which I don't speak for, would be very concerned if people were applying for a visa in order to apply then for protection. Though it can happen on humanitarian grounds, and the reason that it's very difficult to kind of scope out why or how these systems run is because the discretionary element is actually very flexible, and it allows people, particularly in officialdom, to listen and see and hear the particular circumstances of the individual, and though we mightn't have a scheme which ticks all the boxes, this allows us a mechanism to offer help. And I understand the frustration of policy analysts when they say, well, would you not write that down and see how people can qualify? But I know in my own daily practice, I've come across particular cases which are very serious, and I haven't got a scheme in which I could get somebody in here. But if I have a discretionary power that I can use, that can sometimes solve my problem. So I can see the dilemma in protecting immigration systems, in getting people a quick access to a protection, and also in having that flexibility and that discretion that sometimes is necessarily opaque in order to provide the space where a humanitarian response can be given, which doesn't necessarily tick all the boxes.
Thank you. A brief question before we then unfortunately have to close that I would like to pose to Jana. Jana, the audience is also asking that they thought it's an interesting overview, those different types of legal channels that we have discussed today, and also what Germany has been setting up and how it interlinks with other protection efforts. And the question is how can the political will be mobilized to engage with these different types of protection efforts? What can be done? And maybe you can reflect what has stimulated in Germany maybe the adoption of different kinds of legal channels and offering that to those in need of protection.
Okay, thank you very much for that interesting and important question. And well, there are reasons for all of these different programs, for sure, and they differ. For example, the humanitarian mission program for Syrians, or those 3 programs Germany set up, were actually before the great influx, and we have to keep that in mind. And at that time, especially in 2014, NGOs and other Syrian migrant organizations and so in Germany put public and political pressure, and that helped to actually set up and to get almost 20,000 Syrian refugees and family members via this program to Germany. That differs from the other programs, but sure, it is also a question of public opinion. It is the question of parties, and if we have a look at the recent political debate and coalition negotiations in Germany, there is a debate on the maximum yearly capacity of humanitarian admission in Germany, and that actually includes all the different programs, which you can see in the annex of my slides, but which I also highlighted, and it includes family reunification. So it is also a question of political will and public opinion, and that's also the strength maybe to set up special programs sometimes for a specific group of people, because that works and has worked for several decades in Germany, because there's a long tradition of humanitarian mission programs for selected groups of people and countries of origins and countries and crisis in Germany.
Thank you, Jana. Yeah, it's very useful also you pointing out the more historical evolution in Germany and how some of these programs indeed emerged before the onset of the crisis and what actually stimulated their adoption. Brian Merriman, would you want to add anything in terms of that, in terms of how to mobilize the political will to engage or to set up different types of channels or a combination of those?
I think it's very important for us to make sure that the debate is not about labels. It's not about refugees, migrants. It's about people, and people who have a particular need that may be of use to our countries, but also that we would have a humanitarian obligation to respond to. And very often it's very difficult to see the human beings in the broader political debate. And I think that we really need to, make sure that the debate is properly informed, make sure that the society is allowed to respond in a positive and humanitarian way. And that can sometimes mean managing situations. And, because on my job, I'm trying to manage a very limited supply of resources. And the one thing, and we've seen it in certain countries in Europe, that, by opening the doors, which was the right humanitarian response, it actually had a big impact on the existing systems. We have no unemployed social workers in Ireland at the moment. If we take in a lot more children with needs, they won't be properly looked after. And I think there's a constant desire to try and A, access resources here, B, make sure that nobody is disadvantaged by opening our doors even further, and of course C, that we do respond to the great human plight and the human need that has become very apparent in the last few years in Europe.
Thank you, Brian. I'm conscious that we're going slightly over time. We'll just take a few more moments to take a couple of questions. Another question that I would like to just briefly direct to Brian Merriman, and is also, you were mentioning that as part of the Syrian humanitarian mission program, that originally those who would be allowed to enter the program were actually those who would have point out that they have a relative, have financial, and that those person then actually have the financial means to support that person that arrives. And you mentioned that unfortunately for some of these who entered, about 50% did have to enter the asylum process. Could you elaborate a bit further? Do you mean that they were then not able to be supported by those who originally had agreed to sponsor them or to take them on?
Yes, it was a combination of factors. As I said, first of all, the family member that they were joining wasn't necessarily somebody that they knew very well. So therefore, when you put them all in the same house, etc., there can be tensions between adults, as there would be between you and I, if we had to live together. It was a very difficult thing to sustain in the long term, and I think that was a challenge for people. And to be honest with you, I'm very pleased we did it. The downsides were that it was confined just to people from Syria, and we know that conflict is much broader than that in the world today as well. And I suppose, in our next program, the Irish Refugee Protection Program, we made sure that each individual had a rights-based admission to the country, and that the state would move in and offer them a much broader range of supports than had been available under what we call the SHAP program. So, I think it was a very good start. It was the right thing for us to do, but I think that the lessons we learned were well reflected in the next programs, and we raised the bar in relation to protection and services provided.
Thank you. Maybe a final question before we then close this webinar. Jana, there's also a couple of questions that have been raised in terms of the quota that are set for these different kinds of legal channels. Would you briefly explain how this happens, how these quotas are set within Germany, and any kind of influences that maybe rise or decline the number over the years?
Yes. Well, again, that differs very much from program to program, and maybe you can, I don't know if you're able to, because I cannot see the slides due to technical problems, maybe you can switch to the slide where you can see the different humanitarian mission programs and schemes in my slide. So you have 7 different channels there, and you can see the numbers. And so it differs very much. There is no real quota for some of them, because it's more or less an individual scheme, but by now with several thousand people having entered. And then you have quota-based programs such as the Humanitarian Mission Program for Syrians. It's in the second row. So there's 1, 2, and 3. And that was negotiation by the federal government with the federal lender, as we are a federal state, and in the end they came up with the numbers 5,000 in the first program, 5,000 second, and 10,000 in the third, which they thought could be managed in that time. And that again differs from the resettlement and relocation program and the quota, which is set by the EU, which has a more very differentiated quota mechanism, which you can actually find in the annex, which of the program, which takes into account the number of people living in the country and so on, the economy status or the unemployment rate and so on. So we should or would have to get into detail for each of these programs because it differs.
Okay, thank you, Jana. I think we'll have to conclude now. I would like to really thank the audience for participating and our panelists for joining us today and providing us with their insights in relation to this particular theme. We apologize if not all the questions were answered, but we could not go further at this moment in time. We would like to remind you that the audio from today's webinar will be available at www.migrationpolicy.org/events. And if you would like to check any of the reports that have been discussed today, you can find those on our website, mpieurope.org. These are tracing the channels of refugees that used to seek protection in Europe and engaging communities in refugee protection, the potential of private sponsorship in Europe. For any reporters on the call who need more information, you can email Michelle Mittelstadt at communications@migrationpolicy.org. Thank you all.